Moments of inspiration mixed with time to network, IBJ Media Events has you covered. From industry deep dives to awards celebrating Indiana's top leaders, see what's coming up and reserve your seat at ibj.com/RSVP.
Welcome back to the Indiana Lawyer Podcast. I'm your host, Maura Johnson. In today's episode, I sat down with Caitlin Visco, an intellectual property lawyer in Barnes & Thornburg's Indianapolis office, to talk about IP and trademark law and how it's evolving in response to the rapid development of artificial intelligence. Last month, artist Taylor Swift filed 3 trademark applications with the U.S. Patent and Trademark Office, with many speculating that the singer is pursuing the filings to protect her likeness from AI misuse. The applications include 2 sound trademarks for her voice and 1 visual trademark of Swift performing during her mega-popular Eras Tour, which ran through 2023 and 24. In today's episode, Visco breaks down what the trademark applications are requesting, what legal hoops Swift's team may have to jump through to get them approved, and how these filings reflect where IP and trademark law could be headed in the age of AI. But before we get into the conversation, here's a word from our sponsor, Taft.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
For those who are maybe unfamiliar with the news itself or just the concept at all, can you explain just what's going on with these trademark filings and what's newsworthy about it?
So what is newsworthy about it is the novel nature of what's happening.
Mm-hmm.
Taylor Swift is a kind of prolific trademark protector. I think she has hundreds of trademarks in her name. But generally, what I think is super interesting to the IP nerds like me is that this is a novel concept and that she's filing for sound marks and an image mark. And so she has filed 2 trademarks for specific audio recordings of her own voice. I think one is, "Hey, it's Taylor Swift," and one is, "Hey, it's Taylor." And then she has also filed a very, as you noted earlier, iconic image of herself from her last tour. I think she has her shimmery bodysuit on with boots and her guitar. And so they're different in that it's not, maybe one of her trademarks is Taylor Swift, just her name, just the words. And that is the type of trademark that we see regularly, right? That we're just inundated with as consumers. But the sound trademark, specifically the sound of someone's voice, is what is a novel concept.
Yeah, that was something that I know as I was reading up on this was kind of the pinging point was, I think I read that Matthew McConaughey maybe did it last year, and that was interesting.
Yes.
But I mean, I guess, how do you go about this in the IP world? Can you just break down just the novelty again of the show?
So Matthew McConaughey, yes, he was the first one to do it. And I think the real IP nerds like me were like, "Oh, this is interesting." But I don't think it certainly didn't get the same amount of press as Taylor Swift, because when Taylor Swift does anything at all, it's very interesting, both from a public perspective, and then obviously this is with the novelty of her legal standing. So generally, and you can please stop me if I get too into the weeds of kind of the IP realm. It is my weird passion. So generally, there are a couple different ways for really famous artists, musicians, celebrities to protect kind of the IP around themselves. One would be a copyright, right? And so in Taylor's case, it's like her music, the lyrics, all of these different things. And that's protected by a copyright. A copyright is a creative work. Then you have the right of publicity, which we see a lot now with all this talk of NIL and all of these name and image likeness things. So the right of publicity is different from copyright because copyright is federal and the right of publicity is a state by state thing. So some states don't even have it. Various states have different types of rights about what is protected under the right of publicity. And then the trademark protects the brand, right? Mm-hmm. A trademark tells us who is providing this. So, for example, one of the most famous trademarks is Coca-Cola. And so the whole point is when you go somewhere and you get a Coca-Cola and it has the Coca-Cola trademark, you know who has created this, right? Who has made this? You know the quality, the source, all of these various things. And that's what trademarks do for us. And so sound trademarks are things that they're certainly more rare. And you think of these iconic sounds related to, I think someone has written a lot about the Netflix ta-dum sign or NBC's chimes. I think MGM maybe has one. So it's things that you don't necessarily, or like lots of jingles, things like that is usually where sound marks come in. A sound trademark is just one of kind of a different amount of non-traditional trademarks. So your traditional trademark would be like Nike, the Nike swoosh, Coca-Cola, Google, the word mark. And non-traditional trademarks aren't only sound, but things like Apple has a trade dress registration for the setup of the Apple Store. So if you look, it is a registered trademark. So if someone were to create a store and it were to have a very similar setup to an Apple Store, they could enforce their trade dress protection. And so this sound is meant to stop others, obviously, from using this kind of similar sound in a way that would confuse consumers. So if someone else started using the Netflix sound trademark registration, Netflix could write to them and say, stop doing that. And so from the Taylor perspective, and the reason that this kind of Matthew McConaughey, Taylor Swift theory or strategy is unique is because generally we haven't seen celebrities or really anyone do this kind of voice, right? It's their own voice. And the kind of common understanding is that the reason they have done this is to stop AI misuse of their name, image, likeness, and also their voices. And I think anyone who exists in the world right now hears about AI all the time. And I think it is something that we don't know 100% how it's going to be protectable, right? I think there is an article where Matthew McConaughey's own lawyer says, we don't know how it'll hold up in court, but it's something that we need to try. And so a lot of times the whole goal would be to get a trademark registration at all. It could have this deterrent, right? So whether or not it's actually going to be successfully held up in court, there could be a deterrent if you have this registered trademark that you send to an AI platform and say, stop using my trademark. They might be scared enough to just take it down on their own. It might never even need to get tested in court.
Okay. That's interesting. And I think another thing that I was reading up on is just the specifics, I guess, of the filings. Like, obviously, you said she hates Taylor Swift. I guess when it comes to filing it in that way, how broad or narrow, I guess, are her requests, especially up against AI?
So that's a really good question. And I don't think we quite know the answer to that. I think this is going to be our use case that tells us how broad or narrow they are. So on their face, they're quite narrow because what the phrase is narrow. Hey, it's Taylor. That is a pretty narrowly confined trademark. Mm-hmm. But my belief is that the argument becomes, once that is registered in her voice with her specific timbre and cadence, that they will then use that as protection for her voice. Generally, more broadly. The trademark infringement analysis, so whether or not you can sue someone for trademark infringement, involves a number of factors, but the overarching test for trademark infringement is called the likelihood of confusion test. So when a general average consumer sees the infringing mark, or in this case, hears the infringing mark, are they likely to be confused as to its source of origin, who is providing it? So the argument would be potentially that anything said in Taylor's voice is going to then be confusingly similar to this, hey, it's Taylor trademark. I think that is where it will go. And whether or not that can be proven is going to be fairly difficult. Again, I think my greater belief is that it will just serve as a more general deterrent. But if someone wants to dig in, one of the big AI platforms or someone else wants to maybe make this free speech argument, we may ultimately see it get played out.
Yeah. Well, and I think another maybe layer that is interesting specifically about Taylor is obviously it's a speaking trademark, but obviously she's also a singer. Is that something that would cover if AI is trying to infringe on her singing voice, which might sound a little different than speaking? Is that
That's a really good question. So that is a very good question. So generally, like her songs, the recording of the song,
yeah.
and the lyrics to the song, the music to the song, all of those separately are protected by copyright. But what, to your point, what AI is going to do is not necessarily, someone's going to plug into AI, is not going to copy the exact record. It's not going to copy her famous song because that would be copyright infringement. That's easy. But if they used her voice to generate a brand new song, that's a really good question. And I think that's what remains to be seen, right? Is whether or not, how far can she extend her voice? And I think the other thing to keep in mind from a trademark protection perspective, or like the whole purpose of trademarks, is that it has to be a brand identifier. And so if you look at sort of a lot of the academic articles that have dug into this, what a lot of trademark professors and IP professors are saying is that this is not brand protection, right? It's not protecting the brand itself. It's protecting kind of her as a celebrity. And maybe we might all look the other way because she is so well known, she is so famous, but that this isn't necessarily a designation of source. Just because you recognize it doesn't mean that you assume that it's related to her. And I think that's just a really interesting, it could make your head really explode as a trademark attorney to keep going down the rabbit hole of that. But it's interesting. And the other thing to think about is all of the USPTO, the Trademark Office records, are public. So we will be able to see once it gets examined, now that, of course, everyone is aware of it. When everyone became aware of the Matthew McConaughey ones, they had already gone through examination. But here, I think people are going to be watching very closely to see, what does the USPTO say? And if they raise certain objections, what does Taylor Swift do in return to overcome those objections? Because I think it creates a roadmap for a lot of other people. I mean, we already have clients asking, how can I do this? Will I do this? Should I do this? It is like a weekly thing that we are making a roadmap considerations to look at.
Yeah. Well, and going off of that, from your perspective as an IP attorney, what is, I guess, maybe the legal hurdles that you anticipate as the applications are going through and going up against the US patent? What are they having to deal with? Do you anticipate?
So there could be things. It could be distinctiveness. And so trade perspective, your trademark has to be distinctive. And that's what I've been talking around. I just haven't been using the word distinctive. And it tells you, it actually identifies a source. It doesn't just describe it. It doesn't just bring it to your mind. So it must be distinctive. And that is a trademark 101. So you couldn't register something, you couldn't register computer for a computer. That's a really bad example that I'm trying to think of off the top of my head. But things that are generic and things that only describe something, things that don't tell the consumer who or what, are not distinctive, right? If it doesn't point to a specific source of origin, I think given that the Matthew McConaughey ones were able to go through on distinctiveness, I don't doubt Taylor Swift. I think there are a lot of different questions about really any other celebrity in the world. I think Taylor Swift will be able to have the data to make it clear that these are distinctive.
Yeah.
They must be used in commerce. The trademarks must be used in commerce as filed. I'm certain she has all sorts of evidence of showing of her using those specific phrases, right? Hey, it's Taylor. Hey, it's Taylor Swift. I think she probably uses them like on Spotify or on other commercials. And so that is something that should be fairly easy for them to prove if they get an initial objection. And then the other thing that I've seen a lot of people talking about and considering would be the non-functionality. So something cannot be functional. That's why we aren't able to really protect a lot of fashion design, things like that via trademark, because they're functional. If you're trying to protect the shape of a garment or a handbag or these various things that are functional. So the shape of a screw, or if something has to be a certain color, a lever or something, then the color itself may be functional. And so the point of not being able to trademark something functional is that other people need to be allowed to use it. You can't have a monopoly on something that other people should be able to use. And so I think any of those could get raised. I anticipate that she will have the evidence just based on her sheer celebrity to ideally overcome those. But I think seeing how they get raised will, again, provide a roadmap to maybe lower tier celebrities, of which, of course, everyone is one, on how to do that and what types of evidence they would need to prove to overcome that. So things she might need to be required to submit would be like album sales, number of commercials she's starred in, all of these different things. It's really data to show that when someone hears, hey, it's Taylor in this specific voice, they know what Taylor it is, right? There's no doubt in their mind that this is Taylor Swift and this is endorsed by Taylor Swift if it's using her voice in that way.
Yeah, that's interesting. I was going to say, I think a big topic of conversation maybe a couple years ago was, I believe it was AI that had morphed her voice into like endorsing politicians, and
Yes.
I fired back on that.
Yes, we think that's, I think, I say we, the trademark world, I think that is a really big one, right? These kind of deep fakes as well as the endorsement. And I think the endorsement, that is one, I mean, it's a clear, tangible harm to her, right? And so I think that this makes a lot of sense for her because it's difficult for her from other forms of IP, right? There's this right of publicity action, there's this copyright, but when they made a deep fake of her or made this AI endorsement of her, they did use her right of publicity, but it's like, where would you sue them? And where all of these different things and suing them under state law. And so the goal would be to get some protection that is more federal in nature via a trademark and perhaps broader in nature to be able to just add that to the tool belt.
Yeah. When it comes to obviously getting it trademarked here on a federal level, how does that maybe impact what's happening overseas when it comes to, I don't know if there's AI companies that could do that overseas. I guess, what does the regulation look like for those situations?
That's a really good question. So trademarks they're geographical in nature. So she could get this US trademark. And then if she wanted protection in other jurisdictions, she would have to file in other jurisdictions. And some jurisdictions do also identify or they respect sound marks or different trademarks, but a lot of jurisdictions don't. So the problem that may happen is if you have a US trademark and you want to go after perhaps a Chinese-based AI platform, you might not have the recourse, right? They might not accept it, which is going to be another significant hurdle to watch how this identifies. And so it would be trying to get this hook to stop them in the US. But if it's just something that's coming out of another country where you don't necessarily have the same level of protection, I think it's going to be interesting to see, one, how the law evolves generally. I would anticipate that then in the next few years, we will see regulations, ideally, will be at the state level, at the federal level first, but then probably the EU is really high on data privacy, all of these different I think they're a little more nimble and they are really willing to look at the regulations. And so I could see the EU taking a really specific stance on this type of AI trademark deepfake regulation.
How does this topic kind of fit into that overall conversation of regulation here and monitoring in the United States?
I think it's probably a low priority for the people that are looking at that, right? I think part of the issue is it's moving so quickly and we really don't have a handle on it. I just saw something about how we could never move at the speed of AI because AI has already found out how to copy itself onto other computers, which is terrifying. And it's like it's writing its own code, right? So I think that on the priority list, it's fairly low. But I also think that there are a number of things that this needs to ultimately fall into. And I think that it becomes part of this protection of people, right? This understanding of that you could do a lot of damage by having the ability to, and anyone can do it. Anyone could make a deep fake of Taylor Swift today very easily. And this type of damage that can be done to people in their lives and their livelihoods, and this type of things that can happen to consumers, right? I think the first thing that I think of as a parent with AI is like so terrifying what could happen to children, right? This protection of children. And that type of thing is obviously higher up than this. And so I think really it becomes a business case. I think when the very large companies start to get involved in trying to help change the regulation about how IP is used or not used by AI is when things will really start to happen. So I think I recall there was an issue with Disney and that maybe it was Gemini or one of the other AI platforms was recreating or helping people recreate like Disney princesses or Disney characters. And I think that Disney sent them a cease and desist and was able to directly work with the platform, right? So the regulation and the kind of acceptance needs to come through the AI platforms, right? No, it's not going to, if you don't really want a cause of action against random consumer. So random consumer who creates a deep fake of Taylor Swift, oh, they're fined $500. Like that's not really going to work. What needs to happen at the platform level, at the company level, is to say, we will block or stop or whatever users from being able to do this.
Mhm. And you touched on this a few minutes ago, but in what ways does this story for you reflect where trademark and IP law are headed in the next few years?
I think continually for novel approaches for where trademark law or other types of IP law can fill in the gaps of what is currently missing. So I think one thing, not necessarily AI specific, but this thing that I talked about of functionality in the fashion law world, I do a lot of work in kind of the fashion and luxury world, and it's always been a hole that's there, this protection of functional things. Another thing that I talk about incessantly is dupe culture. And so this kind of influx of dupe culture in our society and how social media has impacted dupe culture. But I think it all comes to a head, right? Because people type into AI, hey, I want a dupe of this Louis Vuitton bag, and 700 pop up, right? Because AI can scour the internet better than any search engine and show all of these different dupes. And so I think that we will start to see more global regulation hopefully of trademarks, but trademarks in the AI era. I think it could start as easily as it could start at the state level. And I do believe that it already has. It could start like states could say, so I think Tennessee came down in 2024 and changed their right of publicity to include voice, which some don't, some states don't. And so I think it can start slowly like that, right? We might see, I doubt it, but we could see like a federal right of publicity type action to support a federal copyright action, a federal trademark action. But I think it really is, it's the Wild West at this stage. We just don't know what will happen. And I think it won't really go away in the same way that some trademark trends went away. So the big one that I always think about was like the metaverse, NFTs. So when that was really hot, it was like every company wanted to file a metaverse trademark, an NFT trademark, cover all these things. And you were like, you're Home Depot. So you don't really need that, right? And so I think that some people liken it to that and say, oh, everyone's AI is this trend, but it's really not. I mean, I think that anyone who's paying attention can see that it's something that is going to significantly impact every single area of our life. And I'm certain there are people much smarter than me considering this on the really global level. But the hope would be that the USPTO, so the Patent and Trademark Office, could come down with a proposed regulation that could then get approved about use of trademarks or use of voice and likeness and all of these various things to try to protect both brand owners and people with a well-known name, image, likeness.
That was my last question before I stopped the recording. Is there anything else that I didn't touch on that you think is important in this conversation?
Yeah, I mean, I guess the only other thing that I would think about would be like how it will actually play out. So I think a lot of people will say, okay, if it gets approved by the USPTO, by the trademark office for specific trademarks, that kind of seems like the easier point.
Yep.
One thing I will be watching for would be if anyone seeks to oppose your trademarks. So once it makes it through the USPTO, what will happen is it will open to a open period for anyone who has could be potentially damaged by these to oppose her trademarks and say, hey, we don't think she should be allowed to have these trademarks for XYZ reason. And it's very interesting because any of the big AI platforms arguably could make a very baseline statement of standing. And it would be very interesting because I would bet that they don't want to go up against Taylor. Certainly no one would. She has a lot of ability to fight back. But at the same time, this could be something it's going to be, they could argue this kind of functionality that impedes on free speech, all of these different things, right? That someone's going to be using it in a way because it's not distinctive. Her voice is not distinctive or her voice is not XYZ. So someone may try to take a stand at the trademark office. But also I think one of the most important things is her even doing this without the trademarks even being registered at any stage. It has clearly sent this signal that she is looking to be more aggressive in the protection. And that alone may be worth a lot for the AI companies who are probably, again, not wanting to fight with Taylor Swift.
Thank you for listening to the Indiana Lawyer Podcast. For more legal news from around the state, be sure to head to our website at theindianalawyer.com. While you're there, you can also find more episodes from the podcast and subscribe to our daily newsletter, which includes the latest legal updates delivered right to your inbox. You can also find stories from across the IBJ Media Publication Network, including the Indianapolis Business Journal and Inside Indiana Business.
I'm Tiffany Souter, mom of four, wife, entrepreneur, and host of the Life of And podcast. For years, I built my life with brute force, a successful business, a growing family, and absolutely zero margin. I was tired, snappy, and felt constantly behind, and I was too afraid to admit it. Everything changed when I stopped trying to do more and started building systems that actually worked for my real life. If you too are craving more peace, more presence, and just more time for you, I'd love for you to join me on the Life of And. Subscribe now on your favorite podcast app or listen at ibjpodcast.com.
Thanks for listening to this IBJ Media podcast. You're probably going to remember this ad. Do you know why? Podcast advertising works. 85% of listeners recalled hearing an ad during a podcast, and 70% of podcast listeners have acted after hearing an ad. So whether you're looking to be heard across the entire IBJ Media Podcast Network, sponsor one of our shows, or just start with a 30-second ad, IBJ Media can help. Contact advertise at ibj.com to learn more.